Be cool, be kind, be classy. The cupcakes are sweet and sexy. Have fun and enjoy the journey. Just have a good attorney. No big whoop, no biggie. She lives near New York City. And not just a YouTube show. When you know, you better grab a straw. Learn about the law. It's cool here in the shade, sipping motions of lemonade. Cool heads will prevail, kindness will never fail. Be classy and vastly wise. Oh, Melanie Little is going live. Oh no, where is Melanie? Follow the island's melody. Is a concert within reach. No surprise, she's at Jones Beach. She heard some music far away. Captain Jack Sack Harbor Bay. He sings and his piano plays. Not all sounds are waterways. Speaking Yiddish and Latin, it's not just for Manhattan. It's for Goethe and Machegas. Ridiculousness that insanus. Oy vey, Marcus. Proceed, that's for schmucks. Be cool, be kind, be classy. My cupcakes are sweet and sassy. And not just a YouTube show. When you know. Cool heads will prevail. Kindness will never fail. Be classy and vastly wise. Melanie Little is going live.
Hello, my friends. Good evening. Today is Monday, July 28th, 2025. And yeah, there's some breaking news in New York City right now. I had to make sure that everyone that I know and love that works and lives in the area is safe before I came on the air. So I'm a little bit late. I apologize. But tonight we're here for Aaron Spencer. So we're going to stick with Aaron Spencer and we're going to try and we'll see. We'll see what happens by the time we're done with the Aaron Spencer show. If we pivot on over to the breaking news in New York City, not a lot to report right now. There was an active shooter in one of, I think, near the Bank of America building in New York City, and 52nd Street is shut down between Lexington and Madison. I believe that there may be at least one cop deceased, and maybe two, maybe six people altogether. But the reports are sketchy, and so I don't want to get into it right now because there's a lot of stuff happening. And literally, and the weird reason I found out is because someone texted me, "Are you safe?" And I'm like, "What do you mean?" And then told me, and then literally like 10 minutes before I got that text, my daughter had just gotten off the train back home from the city. So it's crazy. The world is crazy. It's a crazy world out there. And yeah, that's insane. It's insane. Right around the Bank of America building. Blackstone is over there too. And that's all I really know. So maybe we can pivot over to that. But if you need to go check that out, feel free. There's a lot of conflicting reports, right? So it's hard to do breaking news. And we do breaking news a lot. But then a lot of the times it's all not, turns out to be not real. So let's try to stay on topic. We're going to go back to Arkansas today for the case of Aaron Spencer. And August 8th is supposed to be the pretrial conference on this. The trial is scheduled on Aaron Spencer for September 22nd to 26th. So this is coming up pretty soon. I'll give a quick overview for those of you who are not familiar with this case. And for those of you who are, it'll be just a little quick summary for you. And for those of you who don't know anything about the case at all, I have extensive show notes below this video. If you're on your phone, you may have to close out the chat to get to it. That will give you the basics. And I have to be really, really careful about what I say and how I describe this situation because YouTube does not want me talking about it. I don't know if they've upped their game on their AI bots that go around and scan the chats and the shows, and they are censoring a lot of stuff. And the last show that I did on Aaron Spencer, this is my third, was immediately flagged as not friendly to advertisers. I appealed it twice. It's still not friendly to advertisers because they don't want us talking about this. Of course they don't. Just like Judge Barbara Elmore didn't want anybody talking about this. Because Judge Barbara Elmore is the same judge who let Michael Fosler out of jail for $5,000 cash. And now she's going to be the judge who's trying Aaron Spencer. I don't know. I feel like there's a little bit of a conflict there. I just do. I feel like there's maybe a little bit of a conflict there, but I'm a New York lawyer, right? Not an Arkansas lawyer. This is a town. It's in Lonoke Superior Court, or in Lonoke County. There, I've learned from you guys, because you're so friendly, that there is a town called Lonoke, and there's also a county called Lonoke. The town of Lonoke has a population of less than 4,000. The county, I can't remember the population, but it is about 24 miles east of the Bill and Hillary Clinton National Airport in Little Rock. I had no idea they had an airport named after them. But there you go. I've never been to Little Rock. I don't know what it's like. So let me tell you a little bit about the story. We're going to use just the letter R for the word that rhymes with grape. And I think you know what SA is. And I think you can figure out what, I can say CSAM, I guess. You guys can figure that out. And I've tried to redact anything that they're going to find offensive here on the tubes of you. But the more I dig into this case, the more it offends me personally, and the angrier I get, and the more outraged I get. And I hope that you are going to be outraged about this too, because Aaron Spencer needs to be freed. This is insane what they've done to this man. This is insane. And you should be outraged. Not just because, look, all right, a man lost his life. There's got to be some charges, right? Maybe. It'll get sorted out by a jury. Maybe. Second degree M on a case like this, really? And then something like Aaron Spencer is charged on November 27th of 2024. And then I have my dates here in the summary. November 27th of 2024. And then it's by like December 9th, December 10th, 30 days, 13 days later, 13 days after he's charged, Judge Barbara Elmore of the Circuit Court, First Division, Lonoke County, Arkansas, slaps a gag order on this case like I've never seen. Gagging not only the attorneys, but the defendant himself, his family, anybody who may be a witness in his case, law enforcement, whether they're involved in the case or not. And it's chilling. And they had to take it all the way up to the Arkansas Supreme Court. And the Arkansas Supreme Court overturned the gag order finally, but the gag order was not lifted until just June 20th of 2025, a little more than a month ago. And the case is ready to go to trial. So this is insane. I am outraged about this, and you should be outraged too. And the fact that this Judge Barbara Elmore is going to try this case after she's the reason that Michael Fosler was out on the street reoffending with the exact same child victim that he offended the first time, that he was indicted, that he had 43 felony charges pending against. It's insane. It is insane. They don't like the First Amendment in Arkansas either, folks. You thought Massachusetts was bad? What do you get a load of this? This is bad. So as I started digging into it more, there's not a lot of court documents available, because when they issued the gag order, the entire court file was sealed, and there's very few filings. So what I want to do tonight is I want to go over the gag order motion that was filed by the state, and then the response to the gag order motion from Spencer's attorneys, because that gives us a lot more facts about what happened that we've only been able to glean through news articles and such. We already went over the opinion of the Arkansas Supreme Court in I think it was the last show that we did. And yeah, you got to catch this live, because you never know when YouTube's just going to take it down for no apparent reason. I know. Music to my soul. And I still don't know what that was about. It was about the, Serena Vanderwood. I have no idea. for no good reason. Somebody else said that. Somebody else had the same thing happen. It's been a minute. Exactly. Lisa Amore says there's no way that teen was that monster's only victim. One just doesn't start committing CSA in one late. He's 67 years old at the time of the offense. I fell into such a, call me Alice. I fell into the rabbit hole on this one, folks. I found his wife's obituary. I found on YouTube, the wife's funeral is on YouTube. It turns out that Fosler was the chief of police in a town in Indiana, something like maybe 15 years before this. Smash the like button, share the stream out, because who knows if it's going to get taken down or be shadow banned, because there's a whole new layer of censorship out there. And there's some people that don't, I don't know, there's some people, some powerful people who don't want you knowing about this case. It's insane. And this case is supposed to go to trial less than a year from the indictment. He was, what did I say? He was arrested on November 27th, and we're going to trial September 22nd. Yeah, I have the docket of his charges. I went over that, Cherie. I went over all of the charges. I was demonetized for that, but it doesn't have, what I'm looking for is the actual probable cause affidavit. I want to know why he was arrested, what exactly it was for. I mean, I saw the list of the 43 charges. Thank you for that. But I already gone over it. Everything else is sealed. All the affidavit is sealed because the judge said, because it's a minor victim. Well, that's okay. You can redact her name. We can still see the probable cause for it. They released everything on Madeline Soto, didn't they? And she was 13 also. Luckily, Spencer's daughter is alive because he saved her life. It's outrageous, and you should be outraged. And if I know we have boots on the ground in Arkansas, because I know some of you have said, I'm there, I'm going to go to court. August 8th is the pretrial hearing. And the public really just found out about this. The media was covering it initially when it first happened, all the way back in November 2024. But then the gag order happened, but the media could still talk about it, but they didn't. They chose not to. Aaron Spencer's wife has been very vocal now that she's allowed to speak again on the Facebook page. And here's what she said, because she can say it better than I can. The Facebook page is linked below. I'm not going to put up the post because they'll probably strike me for it. Well, there's a conflict here because I thought she was 13 when it happened, but this says 14, 13, 14. Our daughter was only 14 when a stranger stole her childhood, taken in the night, rescued by her father. Oh, so that was the night that she was taken by Fosler. She was 14. I think when the original charges, when he originally essayed her, she was 13. Let me start again. Our daughter was only 14 when a stranger stole her childhood, taken in the night, rescued by her father. And now she waits to heal while he waits to be tried. We didn't know the man who took her. He was a former law enforcement officer with a long history of predatory behavior, one we never had the chance to see before it was too late. He groomed her online, manipulated her, and took her from her home while we were sleeping. By God's grace, her father found her and brought her home. He saved her life that night. Now the predator is gone, but her daddy is the one on trial. And our daughter can't begin to heal while the man who protected her faces prison. The man who protected her faces prison. She's a child. She's been through enough. She needs peace, not more trauma. She needs her father, not courtrooms. We are sharing her story because she deserves to heal. Because silence protects predators. Because no parent should be punished for protecting their child when the system failed. Please help us share this story for her healing, for her future, for justice. She has already lost so much. She doesn't deserve the threat of losing her daddy, too. Please continue to pray for our family while we face the unthinkable. And that was a post by Aaron's wife and the young girl's mom on just July 11th. There is again a Give, Send, Go that has been set up to cover the cost of therapy and all of the costs that the family has incurred and continues to incur. And I will link it and pin it in the chat in case any of you care to donate. I think it's up to something like $34,000. Do you remember what it was at when we first started covering this story? I want to say it was, I know it was a lot less than that. Let me just pin that in the chat if you feel so inclined, because I know you guys are givers and I know you guys also like to help and you like to have a cause. And we freed Karen Reed, so now we got to free Aaron Spencer. Please do not put that word in the chat, the P word, the PEDO word. It's a word that YouTube doesn't like. They think we're encouraging it rather than speaking out against it. So please trigger warn yourself and try and keep the chat clean. There's nothing worse than working for hours and hours and hours doing research and then doing a show to have it triggered by something that we can prevent happening. Thank you, Eileen Taylor. And Be in Trouble is here. He says, hello, the judge is protecting one of their own. I think she's also covering her own ass because she's the one who let this guy out with $5,000 cash. Okay. How many judges are in this county? How many judges? Oh, and look at this. Alive Through Spite says gag order so severe that the daughter probably couldn't even talk to her dad's attorneys. Can you imagine? All right, let's take a look at what the state did right away, because the state right away moved for a gag order. And let's see what they think their theory of the case is and what they think it's going to prove. This was filed on December 9th. Well, that's not the right document. Hang on. Okay, here's the state's motion for a gag order dated December 4th of 2024. Motion for a gag order. Come now, the state of Arkansas by John Huggins, Chief Deputy Prosecuting Attorney, and for its motion gag order, doth state. Oh, wow, we're back in the olden days. I haven't seen that in a long time. Doth state. Okay, I'll allow it. 1, that Aaron Spencer is charged with M in the second degree, a Class A felony in violation of Arkansas Statute 510-103, and felony with a firearm in violation of ACA 1690-120. I looked it up, and second degree M carries a penalty of up to 30 years. There is no life without parole for second degree M, but with a firearm enhancement, it adds another 15 years potentially. So, possibility of 45 years, and he's something like 36 years old. 2, that these charges stem from his arrest on October 8th of 2024. That defendant Spencer's arrest has garnered media attention and coverage throughout Arkansas and the nation. Additionally, details of his arrest have spread via social media. 5, that defense counsel has issued a press release. See attachment A. It was around 18,000 when we ended the stream last week. Yay for you. Thanks, Annie. And now I think it's up to like 34,000. Welcome to the age of social media. That's what that it's just the way the world is now. And defense counsel has every right to issue a press release. Let me get through this and then I'll yell. 6, that defense counsel has also given television interviews. In one interview, counsel states, we feel very confident that this community is going to come to Aaron's side because every one of them would have done the same thing for their child or their neighbor's child or member of their family. Attorney Casanelli went on to say, quote, we look forward to the public being more involved in this process, certainly more than they were today. And you know what she meant by that? The arraignment was not open to the public. It was not open to the public. Hold on for 1 second. Give me a sec. Mhm. Okay, moving on. 7, that the state argues that the dissemination by any means of public communication of any out-of-court statements relating to this case may interfere with the rights of the defendant in the state of Arkansas to receive a fair and impartial trial. 8, that the need to preserve the integrity of the jury pool is of paramount importance to ensure the right of a fair trial to both the state and the defendant. 9, the state prays that the court order that no party to this action, nor any attorney or agency connected with this case, directly or indirectly, nor any judicial employee or officer of this court, nor any public official now holding office, including but not limited to law enforcement officials, nor any agent, deputy, or employee of any such persons, nor any person subpoenaed to testify at the trial of this case, 1, shall release or authorize the release for public dissemination of any purported extrajudicial statement of the defendant relating to this case. 2, release or authorize the release of any documents or exhibits or any evidence, the admissibility of which may have to be determined by the court. 3, make any statement for public disseminations as to the existence or possible existence of any document, exhibit, or any other evidence. 4, express outside of the court an opinion or make any comment for public dissemination as to the weight, value, or effect of any evidence as tending to establish the guilt or innocence of the defendant. 5, make any statement outside of court for public dissemination as to the weight, value, or effect of any testimony that has been given. 6, issue any statement for public dissemination as to the identity of any prospective witnesses or their probable testimony or the effect thereof. 7, make any out-of-court statement for public dissemination as to the weight, value, source, or effect of purported evidence alleged to have been accumulated as a result of the investigation of this matter. 8, make any statement for public dissemination as to the content, nature, substance, or effect of any testimony which may be given at any proceeding related to this matter with any attorney of record or any agent thereof. Wherefore, the state prays that its motion for a gag order be ordered. XOXO, John Huggins, Chief Deputy Prosecuting Attorney. And that was, again, December 4th, less than 2 weeks from Aaron Spencer's arrest. Okay, here we go. Attachment A. This is the public. This is the statement. This is the press release of Spencer's attorney that they're complaining about. Late Wednesday, Spencer's attorneys Aaron Casanelli and Michael Kaiser released a statement that read, quote, "We are not just disappointed. We are outraged by this decision." Aaron Spencer is a decorated war hero who protected his country and a loving father whose heroic actions protected his family. He is certainly not a criminal. He did what any father would do and any trained combat veteran would do to protect his child from a predator. This predator repeatedly violated his child and, undeterred by criminal charges and release on a low bond that pales in comparison to what was required of Aaron, kidnapped her in the dark of night to continue his assaults on her. The systemic failures for decades that permitted this man to continue his abuses of women and children for years culminated in his facing a father who finally stopped him. No matter what the prosecuting attorney may do to Aaron, he was able to save his child and prevent this man's continued acts of violence against the most vulnerable among us. Nothing could be more important than that. So, I mean, I'm just going to break from that for a second to say that apparently this guy's got a history. He's got a history for decades of abusing women and children for decades. While the prosecutor has made clear his intent to send Aaron to prison, even targeting his use of a legally owned firearm, and in spite of his past experiences in combat, in this country, it is not the prosecutor who ultimately decides justice. It is the citizens. We believe the citizens of this country and of this state will not allow this injustice, that this community will not allow a father protecting his child from a serial predator to be treated as a criminal. The repeated traumas Aaron's family has endured over the last 6 months are unimaginable. Sadly, the prosecutor's decision perpetuates these horrors instead of protecting legitimate victims and punishing true criminal offenders. Instead of targeting this heroic father, the prosecutor should be working to figure out how the system failed to protect this innocent victim and instead resulted in her father having to do so. We appreciate the support of so many who have voiced their outrage over the treatment Aaron, his child, and the rest of his family have suffered. We will stand up and fight for our right to protect ourselves and our children and will not be deterred by this unjust decision. Please keep Aaron and his family in your prayers as they continue to heal from past events while now managing a criminal case. We look forward to Aaron's day in court and to the end of this family's nightmare. And so it is because, not just, but one of the reasons that the state sought a gag order within 2 weeks was because of this press release by his attorneys. And you tell me, we've seen a lot of press releases by attorneys for criminal defendants. And do you think there's anything in there that like would warrant the gag order that we know was eventually issued? Because I don't. But again, here we are in perhaps, it's exactly what I was thinking, Olivia. The judge is going to keep out mention of the predator's criminal acts towards Aaron's daughter or his prior history of them. There's only been one motion in limine so far, one motion to suppress, and it was for the pipe in the backseat of the police vehicle. But I bet you anything the state's going to want to keep out prior bad acts of this guy, because I'm sure other victims have come forward. I mean, this guy used to be in Indiana, so hello, Indiana. I'm sure there are a lot of victims out there because, as I know from my work with my giant lawsuit against the Catholic Church for As Such Victims and Survivors of Clergy SA, that was a 15-year-long fight in civil court in New York. The typical predator does not even get caught until they've offended at least 100 times. Those are the statistics. It's true. All right, here's the response, the defense response to the state's motion for the gag order, in which we are going to glean some more information about what happened that night because they give us some more detail. And it is partially redacted, so just stick with me for a moment. Give me one more second. Right, we need like a little bit of more mood lighting in here. Just it feels very bright. Okay. This was filed December 9th of 2024, and this is the response to state's motion for a gag order. Comes now the defendant, Aaron Spencer, vying through his attorney, Aaron Castanelli and Michael Kaiser, and states for this response to the state's motion for gag order. Introduction. On November 27th, 2024, the state of Arkansas charged Spencer with M in the second degree with an enhancement adding up to 15 years imprisonment for using a firearm in connection with that offense. The charges resulted from the October 8th, 2024 death of Michael Fosler. The case has garnered media attention because Spencer killed Fosler, while Fosler, having already been arrested and charged with numerous SA offenses against Spencer's child, had Spencer's minor daughter in his custody for the purpose of R-ing her, or worse. Fosler had previously been arrested and charged with 43 felonies for his conduct with Spencer's daughter, including internet stalking, SA, and child P. She was 13 at the time of his initial crimes against her. This court released Fosler on a paltry bond with an order that Fosler could not have contact with the Spencer family. Undeterred by his arrest, Fosler continued his crimes against this child. About 3 months later, after finding his daughter missing in the middle of the night and contacting police, Spencer located her with Fosler, who fled with her in his truck. Well, it seems to me what they're saying here is that even between the time of his release from prison or jail, Fosler, his release on bond, and the night he kidnapped her, he may have committed other crimes against her during that time while there was a restraining order, which is really literally just a piece of paper, as you know. Oh, Lisa says, look up the Boys on the Tracks documentary. It's close to Lonoke too. Lonoke County. Oh, thanks. About 3 months later, after finding his daughter missing in the middle of the night and contacting police, Spencer located her with Fosler, who fled with her in his truck. After Spencer pushed Fosler's truck to a stop, Fosler continued to present an imminent threat to Spencer and his minor daughter, the key witness in Fosler's pending criminal case. And Spencer killed Fosler, saving himself and his daughter from further harm at Fosler's hand. Okay, so this happened on October 8th of 2024. Fosler's trial for the charges related to Spencer's daughter was scheduled to happen December 4th through 6th. 2 months. It was 60 days away. And I think she was the only witness against him. Do you think he was going to return her home safely that night? I don't. As it turns out, although he was never convicted of a crime, Fosler was known by others, both in Arkansas and other states, as being sexually depraved. As can be expected, the Lonoke County community, including the Spencers, has been outraged by both Fosler's lenient treatment and Spencer's unjust charges. Even before the filing of these charges, significant media attention was generated as citizens in Lonoke County and throughout Arkansas reacted with outrage to Spencer's arrest. In light of the obvious public interest in this case, individuals associated with both the defense and the state made statements to the press. Despite an initial willingness of state actors to engage with the press and the public about the heavily criticized decision to file charges against Spencer, the state has now reversed course and requested this court issue a gag order preventing Spencer and others, including public officials or police, from exercising the constitutional right to free speech. The state's aim is clear. By silencing Spencer and his supporters in the community, it might also dampen the media interest in Spencer's fight for justice, thereby shielding the state from public scrutiny and creating an easier path to the conviction and imprisonment of an innocent man. Gag orders are not intended to protect public officials from criticism. And we know that this is exactly what happened. Everybody was reporting on it when it first happened, Law and Crime, Court TV, and now that's exactly what the gag order did. I didn't even know about this case until a viewer brought it to my attention a couple of weeks ago. And as soon as I found out about it, I had to cover it. The facts of this case are not in great dispute. It seems from the state's comments and the charges that it will seek to suggest that Spencer killed Fosler solely out of anger or revenge instead of fear, despite the undisputable facts that led to Fosler's death. It is, of course, the state's prerogative to choose charges and theories. However, this theory is entirely inconsistent with the law. That's right. Heisenberg says, out of sight, out of mind for the media. That was by design. Absolutely. The Spencers, like any parents of a child harmed by a sexual predator, were certainly angry and upset by Fosler's essay of their child. But even if he'd wanted to, Spencer did not kill Fosler after finding out about the essay. He let the justice system proceed to stop and punish Fosler. But when the system failed and Fosler took the child to harm her further, angry or not, Spencer did what was necessary and justified to save her. The law certainly does not require that a person who acts in self-defense or defense of others be docile or loving towards the person they must harm in order to save themselves or others. Instead, the law requires only that he reasonably believed the other person was committing or about to commit a felony involving force or violence, or was using or about to use unlawful, deadly physical force, or where it was necessary as an emergency measure to avoid an imminent public or private injury. And according to ordinary standards of reasonableness, the desirability and urgency of avoiding the imminent public or private injury outweighed the injury sought to be prevented by the law prescribing the conduct. That is according to the Arkansas Code annotated, and these are the justification statutes that they're pointing to here. The defense had filed prior to this an intent to use justification or to raise justification as a defense. Once raised, the state must disprove a justification defense beyond a reasonable doubt, according to the Arkansas Code. Thus, if there is any doubt that the defendant's actions may have been justified, that is, he feared for his or another's physical safety, the accused is not guilty. Further, while a defendant's intent or purpose, that is, their state of mind, is typically not positively known to others, it can be inferred from the circumstances, and the jury may draw on its common knowledge and experience to infer it from the circumstances. Here, there's little doubt that Spencer was justified in killing Fosler, and no reasonable person using common sense would consider these circumstances and find that Spencer was not fearful for the safety of his child at the hands of a man who had repeatedly hurt her for months. Just want to point out that as soon as this gag order was issued, which was like the next day after these papers were filed, the file was sealed. So these papers haven't even been available until the Arkansas Supreme Court overturned the gag order about a month ago. So I don't know if anybody's covered this yet. You can tell me if you've heard this motion before. The state's effort to retool the facts of this case by insinuating they have evidence otherwise and preventing the public from knowing what it is, or what is plainly the reality, should be rejected. Although it's easy to think that an order restricting public commentary would make this case less onerous for some of the participants, the Constitution and our system of justice demand that urge be resisted for the benefit of the defendant and the public. If granted, the state's gag order would represent a clear violation of Spencer's constitutional rights to free speech and a fair trial. The state's motion must be denied. Legal principles. Chief among the freedoms guaranteed to the American people is the right to free speech. This guarantee is enshrined in the First Amendment to the U.S. Constitution and echoed in Arkansas's own Constitution. Quote, freedom of speech is a bedrock constitutional right. Americans are free to speak, listen to others, and make up their own minds about their government and the world around them. The First Amendment reflects a profound national commitment to the principle that debate on public issues should be uninhibited, robust, and wide open. And they cite U.S. v. Trump a lot here. They're using that as their seminal free speech case. Which is interesting because in all the freedom of speech cases that we've covered lately, I don't know that they've been citing that case. But anyway, moving on. Quote, oh, hi, BB. And BB says, I'm the only one. I'm the only one. Thank you. And you. Well, this is important. So I'm glad you guys are here to listen to it because it's important. That is because speech concerning public affairs is more than self-expression. It is the essence of self-government. It is fundamental to our way of life that the government has no power to restrict expression because of its message, its ideas, its subject matter, or its content. Free speech holds government officials accountable. Public criticism and scrutiny of those in power exposes fraud, curbs the abuse of power, and roots out corruption. Speech about judicial proceedings, especially criminal prosecutions, promotes transparency in the legal system and guards against the miscarriage of justice by subjecting the police, prosecutors, and judicial processes to extensive public scrutiny and criticism. The judicial system, and in particular our criminal justice courts, play a vital part in a democratic state, and the public has a legitimate interest in their operations. A defendant's ability to speak about his criminal trial is an important issue, given the First Amendment's broad protection of free speech and the public interest in the transparency of criminal trials and open discussion of the trial process. The criminal justice system exists in a larger context of a government, ultimately of the people, who wish to be informed about happenings in the criminal justice system, and if sufficiently informed about those happenings, might wish to make changes in the system. I mean, you recall in the, I'm just going to break for a second to say, you recall that in the Karen Reed trial, Karen Reed case, there was a gag order, but it wasn't against Karen Reed or her family. They were all allowed to speak. It was the attorneys that weren't allowed to speak. Right? It's crazy. The protections of the First Amendment are not empty symbols of some imagined freedom. To signal to the people that the freedom of speech is a right of the highest value and one to be zealously guarded, our courts have made clear that any attempt by the government to restrain speech on the basis of its content is to be prohibited in all but the most extreme cases. Because it is in the spirit of the First Amendment that citizens feel encouraged and not just allowed to speak their minds, these protections stand against government attempts to punish speech after the fact, as well as attempts to use the threat of punishment to dissuade future speech. Hang on one second. Prior restraints on speech, government restrictions forbidding certain speech in advance of its communication, bear a heavy presumption against their constitutional validity. Like all court orders, hold on a second. All right, well, the breaking news in the New York City gunman story is that they've ID'd the gunman, and there was an officer that was killed. And this manic gunman killed 5 people at 345 Park Avenue on Monday evening. His name is Shane Tamura, Tamura, from Las Vegas. So you don't need to go anywhere, because I just told 27 years old from Las Vegas, killed an NYPD cop and at least 4 others and injured several others. This is a breaking story. They found a vehicle with Nevada plates registered to this guy at the scene with a rifle case inside. This is very tragic. Very, very tragic. I don't know. 345 Park Avenue. Is that one of the bank buildings? I'm going to have to figure it out. So sad. No, I don't know. No, it's like, I think it's where Bank of America has their, 345 Park. I'm going to tell you right now, he looks like Jussie Smollett. Do you remember Jussie Smollett? He looks like Jussie Smollett with a fake ID. Wow. Just give me a second while I don't like to spread information, so I got to wait until it's like confirmed, you know? That is where KPMG is headquartered, as is Blackstone Group. NFL headquarters is also in 345 Park Avenue, as is the National Football League, Bank of America, like their corporate offices. American Express offices. Yeah, I don't know. That's insane. Okay. Yeah, Blackstone's in there as well. A lot of businesses. I shot a commercial in that building. That's the Bank of America building. I know exactly where it is. Wow. Okay. Back to prior restraints on speech. We are in paragraph 6. Like all court orders that actually forbid speech activities, gag orders are prior restraints. Court orders restraining speech about an ongoing criminal proceeding are presumptively unconstitutional. Because the freedom of speech is a right and not a privilege to be earned, it is the government's burden to overcome the presumption of unconstitutionality where it seeks to restrain speech. This burden is a particularly heavy burden where gag orders are concerned. Gag orders warrant a most rigorous form of review because they rest at the intersection of 2 disfavored forms of expressive limitations: prior restraints and content-based restrictions. Strict scrutiny requires the restriction be 1, narrowly tailored to serve 2, a compelling state interest. Yeah, the only state interest served by this gag order was the state's interest in protecting Judge Barbara Elmore. Yeah, I'm going to say the quiet part out loud. From catching a whole lot of shit for letting this guy out with $5,000 cash. There's extensive show notes below the video if you don't know what the case is about, or you're just joining and you've never heard about the case. I'm going to trigger warn you right now. If you don't know about it, you're going to be outraged. You're going to be outraged. Number 8, among those interests which might compel some restraint on speech is the right to a fair trial, guaranteed to the defendant by both the Arkansas and the United States constitutions. Spencer is the only participant in this case with a due process right to a fair and public trial pursuant to the 6th and 14th Amendments to the Constitution and the corollary provision of the Arkansas Constitution. He is not seeking any gag order, and he asserts that restricting his ability to seek information from the public and publicly dispute the state's assertions violates that right. The state does not have an equally compelling right to a fair trial rooted in the Constitution. These rights belong to the people, not the government. We read it. We read it in the state's papers. It's all about, this has to be about a fair trial for the defendant and the state of Arkansas. We saw them arguing that in the Karen Reed case many, many times. Hank Brennan again, we need the Commonwealth is entitled to a fair trial. No, the rights are for the people, not for the government. Let's not get it confused. 9. The public has its own compelling The public has its own compelling interest in fair trials designed to end in just judgments. This is a right belonging to the people and meant to protect the people's interest in a just society and not the prosecutor's interest in an easy conviction. Well done. Well done. Number 10, courts must take steps to protect the integrity of the criminal justice process, giving freedom of discussion the widest range that is compatible with the essential requirement of the fair and orderly administration of justice. Restrictions on speech are evaluated differently depending on the speaker and the connection to the ongoing proceeding. For instance, attempts by the court to restrain the press require a finding of a specific threat of clear and present danger to a fair trial. Citing Nebraska Press Association. And restraints on the speech of trial participants other than the defendant, such as attorneys or witnesses, require at least a finding of a substantial likelihood of material prejudice to the proceedings. Lawyers can make extrajudicial statements as long as they do not present a substantial risk of material prejudice to the proceeding. In considering orders restricting speech about judicial proceedings, the court must in all cases consider both the imminence and magnitude of the danger to the judicial process that flows from the speech and the need for free and unfettered expression. To warrant a restraint on free speech, a threat to the public's right to fair trials must be actual and not merely a possible threat. If there are any lawyers out there who are arguing against a gag order, I'm not going to say copy this motion, but I'm going to say this is really a great motion with a lot of great points and all the important cases. All the important cases. A restriction aimed at restraining speech related to an ongoing criminal proceeding must be intended to combat sufficiently serious threats to the criminal justice process, and if no less restrictive alternatives are available. Thus, in order to impose any type of restriction on speech, the risk of prejudice to the proceeding must be sufficiently serious. There must be no less restrictive alternatives to address the risk, and the order must be narrowly tailored only to effectively address the potential prejudice. (14) Where the public's compelling interest in a fair trial is so threatened and a remedy must be applied, the court should first seek such a remedy among the tools it already has at its disposal in order to find the most narrowly tailored method for quieting free speech. Self-regulation, questioning of prospective jurors, instructing seated jurors to ignore extrajudicial statements, moving the trial location, and postponing the trial are alternatives that should be considered before restraining speech. Voir dire, jury selection, is effective because of the general desire of jurors to express themselves honestly, the desire of lawyers to winnow out partial jurors through questions where permitted and strikes, and the desire of trial courts in assessing credibility and bias to ensure a fair trial. For these reasons, voir dire can serve in almost all cases as a reliable protection against juror bias, however induced. Remember how chatty the sheriff was? I think in the first, it was the first or the second video that we did on this case, We played a little snippet of the sheriff's public statements. He was real chatty in the beginning. Remember the Lonoke? I think it was the Lonoke sheriff. Remind me of his name because I'm conflating all of my cases right now. Aaron Spencer is out on bail, $150,000, far greater than the bail that Fosler was let out on the 5. Yes, you read that right, Jennifer King. He had a trial pending against this child. She's 13. And he kidnapped her in the middle of the night. 43 felonies he was charged with, this guy, Fosler, 67 years old, unknown to the parents. Aaron Spencer, the new defendant, is a combat veteran. And they woke up. She was missing. Her dog was barking, and they got up. And the mom looked in her room, or the dad went. And the mom thought, maybe she's sick. The dad ran in the room. She was missing. They called 911 and said, "This guy, we have a restraining order against this guy. Maybe it's him. Can you go to his house and check?" And the dad ran out, got in his truck, and just so happens he saw them in the truck. He saw the guy driving his own truck with his daughter in the passenger seat. And we're going to get to what happened. Just so happened, just stumbled upon him, and there was a chase, and then there was a shooting. And sometimes we put Dexter up in the corner for reasons that we know about. Because some people need killing. I'm sorry. It's my opinion that people like him, like that guy, cannot be rehabilitated. They just can't. They can't be rehabilitated. Okay? They just can't. It's my opinion. I'm sticking to it. I'm sorry if you don't like it. But this is not a neutral channel. Thanks for coming to my TED Talk. We don't know how he got her in the truck yet. I haven't heard. But I'm sure his daughter is going to have to testify at the trial. So they're arguing here. There's other things you can do besides the gag order. You don't need a gag order. We can question the jurors. It's not going to taint the jury pool. Prosecutor's been talking about it a lot. Aaron Spencer has the right to defend himself in the court of public opinion, right? But no, the judge is going to disagree. You'll see. We're going to go on. If the court determines that voir dire and other available remedies are unlikely to sufficiently address potential juror bias, and therefore a balance must be struck between an individual's right to free speech and the fair and effective functioning of the criminal trial process and its truth-finding function, orders restricting a defendant's speech must be drawn no more broadly or narrowly than necessary to ensure the fair administration of justice. As for gagging a defendant, quote, only a significant and imminent threat to the administration of criminal justice will support restricting a defendant's speech. Historically, courts have employed the clear and present danger test for orders that effectively limit all discussion of the case and to those restricting the defendant's speech, recognizing its First Amendment importance. See US v. Ford, and then they go on to talk about why free speech is important and other things to be considered instead of a gag order, such as changing venues, sequestering the jury, or, a very thorough and robust voir dire. And it also goes on to say, a criminal defendant awaiting trial in a controversial case has the full power of the government arrayed against him and the full spotlight of media attention focused upon him. The defendant's interest in replying to the charges and to the associated adverse publicity, thus, is at a peak. So is the public's interest in the proper functioning of the judicial machinery. The accused has a First Amendment right to reply publicly to the prosecutor's charges, and the public has a right to hear that reply because of its ongoing concern for the integrity of the criminal justice system and the need to hear from those most directly affected by it. And ain't that the truth? And you hear that a lot in chats, right? Because we cover a lot of true crime. We've covered a lot of trials. We've heard a lot of defendants speak, and we've heard a lot of defendants who don't speak. And there is a good segment of the population who is out there saying, well, I know that if they didn't do it, they would be out there screaming that they didn't do it. Right? And this was without a hearing. You are correct, Bubsy, without a hearing. That's what people say. Well, if they didn't do it, they'd be screaming from the rooftops that they didn't do it. Some lawyers allow their clients to speak. Some lawyers don't. You have the right not to testify. You have the right to remain silent. Well, while it is true that permitting the defendant to speak publicly may result in overall publicity that may be favorable to a defendant, more so than when participants are silenced, this does not result in an unfair trial for the government. The Sixth Amendment guarantees the defendant a fair trial. The First Amendment guarantees the public access to criminal proceedings. And it is individuals, not the government, to whom the First Amendment interests attach. To the extent that publicity is a disadvantage for the government must tolerate it. The government is our servant, not our master. Oh, well done. Sounds like John Adams wrote that. What case is that from? Hang on. 1987 U.S. v. Ford. Okay. Although in unusual situations, the balance may occasionally tip against the prosecution, this is an inevitable result of our deep-rooted American tradition of open judicial proceedings. Thus, a defendant's constitutional right to speak is more substantial, and therefore restricting it is subject to an even more demanding level of scrutiny. To restrain a criminal defendant's speech, the threat of prejudice must be specific, not general. It must be much more than a possibility or a reasonable likelihood in the future. It must be a serious and imminent threat of a specific nature, the remedy for which can be narrowly tailored in an injunctive order. More recently, a federal court has explained that in order to restrain a defendant's speech, the court must employ at least the minimum standard of whether the defendant's speech poses a significant and imminent threat to the fair and orderly administration of justice. Statements by the defendant or his counsel concerning the prosecuting attorney or the court, however, are important First Amendment protected speech and should not be restrained. There's a lot of thick footnotes here that I'll leave in case you want to come back and screenshot them and read them. The prosecutor is a representative of an institution and no more entitled to protection from lawful public criticism than the institution he represents. Public statements by the defendant or his counsel about the prosecuting attorney, his office as an institution, or the court should not be restrained. Similarly, comments that the prosecution is improperly motivated or that the defendant is innocent should not be restrained. And citing some more very important U.S. Supreme Court cases on freedom of speech about public scrutiny, promoting transparency, accountability, and integrity, etc. All of these rights that we hold near and dear as such U.S. Americans. Argument 23. On December 4th of 2024, in an apparent attempt to cast a shadow of silence over these proceedings and suppress public support for Spencer's fight for justice, the state filed a motion for a gag order, which, if granted, would impose an extreme restriction on free speech, preventing Spencer, as well as his attorneys, potential trial witnesses, and even public officials with no connection to the trial from speaking to the press or to the public about this case. The state's proposed order would foreclose all speech about the case other than what the state itself has already disseminated to the public. For instance, the state has already publicly shared the factual background of the defendant, the circumstances of the arrest, including the place, time, arresting agency and officer, etc., and the nature, substance, and text of the charge, and its own description of the offense charged. The proposed order permits what the court cannot even arguably constitutionally prohibit from disclosure, that is, quotations from public records or information already in the public domain. Scheduling in this proceeding that is done in public, requests for assistance in obtaining evidence, i.e., a constitutionally required investigation of the matter, and discussions by prospective witnesses with attorneys in the case also a constitutionally required component of representing a criminal defendant. So the state seeks to foreclose anything other than what it puts out in the public domain from seeing the light of day. Footnote 5, which says, interestingly, the state seeks to prohibit comment about public records, which would include, for example, criticism of state action in the case, like this motion for a gag order by the prosecutor or the court, which has no bearing on guilt or innocence. Quashing public criticism of public officials about public business is far afield of the First Amendment. Oh, Gigi's got the silver bracelets already. Just gifted 10 memberships. So welcome to the 10 lucky winners. Welcome. I think you're going to like it here. Thank you so much, Gigi. You're so generous. You are so generous. I love you with all of my heart. Oh, and I missed this one too. Boston Girl 79, aka Charissa, gifted 5 memberships. Thank you so much. Oh, and everyone came over from the Glare. Welcome. Welcome, Glares. Welcome to everyone who was watching well over there. I have to get back and catch up on some of his shows because I haven't been watching a lot of YouTube lately, but we'll get to the super chats in just a moment. Once we get through this. Thank you for gifting, you guys. You guys are amazing. 26. Oh, no, wait, we were back at that footnote, right? Footnote 5. The state complains in its motion of comments defense counsel made when exiting the courthouse after arraignment. These comments have no ability to prejudice a jury, particularly one to be impaneled many months from now. They reiterate the law in this country where the community matters. In fact, that statement does not violate the proposed order submitted by the state with its motion. If the state is suggesting that the statement meant that the defense is confident that Spencer will be acquitted, prohibiting such a statement would be an outrageous violation of a defendant's right to publicly proclaim his innocence. The community has shown support for Spencer, and his family needs that support after what they have been through at the hands of Michael Fosler and now at the hands of the government of Lonoke County. Based on the facts of this case, it is not prejudicial to say that the community's reaction is appropriate and we expect it to endure. The community is entitled to attend public proceedings, to voice opinions through the media and through elections of public officials, and to use those and other lawful means to support other citizens. The community has a right to know what its government does in court proceedings. As counsel indicated at the closed arraignment in this case, the public must be permitted to attend future court proceedings. That's crazy. Anybody who's local in Arkansas, can you tell me why the arraignment was not open to the public? I mean, that might be the first time I've ever seen that. And it's not over yet, right? And it's just 6 months ago. Tiana, the audio bird, says, this is a delayed message. I'm catching up. Boys on the Tracks, Doc. Please do a deep dive. Love whoever mentioned. My family has close ties. All right, I'll check it out. Boys on the Track. My pen doesn't work right now. But isn't it so nice? Look, it's Tiffany blue. It matches the walls. Boys on the Tracks. Oh, that reminds me of that TikTok, the TikTok dancer thing. I don't know, guys. Tell me if you're interested in covering that. I'm fascinated by that and what happened with the feds the other day, busting down the gates or busting through the gates of that compound in California, that M7 company, or is it M7 or something like that? The TikTok dancer cult. I don't know. It's kind of interesting. I got to get the papers though. Got to get the papers. The sittings of every court shall be public, and every person may freely attend the sittings of every court. It is not in any way prejudicial to say that we hope the community is involved in that manner, the very manner of the very manner the Constitution itself demands. The Constitution also gives citizens the right to speak about the operations of their government, particularly about criminal prosecutions, to promote transparency and guard against the miscarriage of justice by subjecting the police, prosecutors, and judicial processes to extensive public scrutiny and criticism. Further, the absence of a jury, long recognized as an inestimable safeguard against the corrupt or overzealous prosecutor and against the compliant, biased, or eccentric judge, makes the importance of public access to a preliminary hearing even more significant. People in an open society do not demand infallibility from their institutions, but it is difficult for them to accept what they are prohibited from observing. I'm interested to know if, Venus Blue says, I just read that this POS was also a school resource officer in Hamlet, Indiana. Isn't that also where he was the chief of police? Listen, I have scrubbed the internet for this guy, and he has been scrubbed from the internet. There are no photos of him. You can't find photos of Michael Fosler. It's crazy. You can't find any evidence that he was the chief of police, I think, of Hamlet, Indiana, right? You just can't, it's been scrubbed. Tell me if, routinely in Lonoke County, if you're there, don't guess, but if you're there, tell me if your court proceedings are routinely closed to the public. What the hell? It's not the way it's supposed to be. Somebody just said here, Barbara Elmore, thank you, C Streetlights, has a history of sealing documents that pertain to law enforcement officers who break the law. She did it in 2022 with a case against a law enforcement officer fatally shooting a 17-year-old. Oh, I see. I see where we're going with her. She like, hey, Judge Canoni, hold my my maker's mark. I honestly, I don't know what they drink in Arkansas. I know that I'm probably Judge Canoni drinks White Claws. And we would say that about Judge Canoni to Judge Gull. Hey, Franny, on my White Claw, I'm going in. Check this out. Oh, girl, Bella Brat, go check it out. Yeah, there was an FBI raid on that guy's house just like yesterday, the day before. Yeah, that was it's the Dancing with the Devil, I think was the name of the documentary on Netflix. And yeah, I think it's interesting. Where was I? Further, the absence of a jury, long recognized. Oh no, we covered that. We're here. The public should be present for a defendant's public plea of not guilty, but that was not permitted in this case. And now the state is attempting to prevent the defendant from even telling the public that he is not guilty. This request is not about protecting the integrity of the jury pool. There are mechanisms far less restrictive than an essentially blanket prohibition on speech that allow the state to do just that. This is really about the state shielding itself from public scrutiny, about keeping the public from knowing about Fosler and how he had an opportunity to repeatedly R a child, even after being charged for doing so. Oh my God, so it was repeated? It was repeated? He repeatedly R'd her even after he was let out on his $5,000 paltry bail? Like more than just this one night, because we do know from the mom's statements that she has posted on Facebook that the night of this incident, they did go into the hospital for a kit, for an R kit, and that we did not know, I did not anyway, know this, that it was repeatedly, it had happened repeatedly, even after he was let out with his piece of paper restraining order and his $5,000, do not pass go. Do not collect 200. Do not go to jail. Amanda Erickson says, no, they aren't typically closed to the public. It's her, Barbara Elmore, and she's going to protect herself and her body as well. Isn't it? I'm so glad that I don't live in Arkansas. I don't practice in Arkansas. And I'm so glad that I'm one of those people. And if you follow me, if you've been with my channel for a little while, even a day, you know that nobody can shut me up. And because when they tell me to shut up, I just scream louder. That's what we're doing, Renee. That's what we're doing. Continue to expose the judge, fellow minions. Didn't think it could get worse, but it was repeated. This is really about the state shielding itself from public scrutiny, about keeping the public from knowing about Fosler and how he had the opportunity to repeatedly are a child, even after being charged for doing so, and about Spencer being able to challenge the state's public assertion that he killed Fosler without justifiable cause. This is about withholding from the public information that has great relevance to the public's evaluation of the practices and decisions of the local law enforcement community, including the prosecutor. It is about shielding public officials from criticism. But the Supreme Court has made clear that criticism of public officials does not lose its constitutional protection merely because it is effective criticism and hence diminishes their official reputations. Citing the New York Times v. Sullivan from 1964. Yes, it is linked below. Thank you, Marcy. One of my second streams on Aaron Spencer has a link to a channel that did a deep dive on corruption in this area going back to the 80s. It is linked also in the show notes below, and the name of the channel, yeah, let me find it for you. It's linked below. You can just click on the link and then just go check out all of his videos because he does an amazing. The name of the channel is called Carnage on Ice. He's got like 17,000 subs, and he does a huge deep dive into like, you know, the good old boys of Arkansas, like going all the way back to like the days of like Bill Clinton, Jay Campbell, Boys on the Tracks, Barry Seal, Asa Hutchinson. Like he gets into it, and he's a great narrator, and he has done all the research, and it's a really, really good channel. And these videos don't have a lot of views. I mean, these videos have like 1,100 views. We have more people watching right now. The word needs to get out. So shout out to Carnage on Ice. Somebody actually wrote me an email. I think I got to get back into my email and said that they're friends with Carnage on Ice. So I would like to talk to him. I will reach back out to you. And so, I mean, his research is flawless. It's spot on. And he's got about, let me see how many videos here. He's got 56 videos. Not all of it is about Arkansas in this case, but he really dives deep into the history of Arkansas and Bill Clinton and that kind of stuff. Is Arkansas the same place where the sheriff shot the judge? Wait, was that Arkansas or is that Kansas? I think it was Arkansas. We got to get back to that. The name of the channel that I was just talking about is called Carnage on Ice, and it's linked in the show notes below the video. Oh, wait, no, that was Kentucky. Wait. It was Kentucky. The sheriff that shot the judge. Yeah, and then the moms that went missing, the moms were from Kansas, and then they went missing in Oklahoma Panhandle. That case is out of Oklahoma. Thank you. Thank you, everyone. Arkansas is AR. No, wait. Arkansas is AR. Right. Alaska is AK, right? And Alabama is AL. I don't know. AK is Alaska. Thank you, Amanda Erickson. It wasn't, I don't think it was Letcher County, Kentucky. Yeah. I know. We always have like 17 side conversations going on in the chat. It's always good for the people with the ADHD. All right. The fact is that the state allowed Michael Fosler to repeatedly R a child and released him with no meaningful restrictions that would have discouraged, if not prevented him from continuing to violate children. The state failed to investigate him fully and to find out the full extent of the risk he posed, not only to the Spencer child, but to other children in the community. Then the state placed blame on Spencer for his having to intervene when Fosler struck again. The community deserves to know this information and to evaluate the propriety of its government officials' decisions in light of it. The community also deserves to be informed and to be heard on the results of these systemic failures. This motion by the state seeks to keep the community in the dark so that it cannot judge the actions of its officials and so that it, in the state's view, may not support a community member who had to protect his family where the state did not do so. Okay, PT. Well, first of all, I agree wholeheartedly with this argument. I think it's fantastic, and I agree. But secondly, KPT says South Carolina, Kentucky, Tennessee is my Idaho, which is what Kathy from Gossip Rumor and Innuendo says. Idaho, Iowa. Iowa. I don't even know how to pronounce it. Yeah, the state knew, which is so bad, Edwina. Yeah, seems that they did, or they didn't do any due diligence to find out about this guy, because I'm sure his history was right out there. He used to be a police chief in Indiana, for Christ's sakes. My God, there's like a hair that I just cannot get rid of. All right, I'm freaking. Hold on a second while I fix this hair. That's in my video. All right, it's freaking me out. Okay. As laid out above, courts have made it clear that such a restriction is presumptively unconstitutional. To overcome this presumption, the state must demonstrate and the court must find on the record that for Spencer to speak publicly in his own defense, for the press to publish it, would pose a significant and imminent threat to the ends of justice, and that public commentary by others involved or expected to be involved in the trial would mean a substantial likelihood of material prejudice to the proceedings. And there must be some explanation provided as to why the court believes it would be futile to employ more constitutionally sound strategies contaminated by press coverage. Even then, it is not enough that these other strategies would fail. It must also be the case that the proposed strategy, some restriction on free speech, would succeed in strengthening the integrity of the proceedings. And if the circumstances are truly so dire as to warrant such a restriction, that restriction must not overstep by even an inch the reach of its usefulness. Ultimately, the restraints imposed and the exact degree to which they are imposed must be found to provide the only pathway to a fair trial. Right, Diane? Just think of how many girls he may have saved. Aaron Spencer. Yes. Ultimately, the restraints imposed and the exact degree to which they are imposed must be found to provide the only pathway to a fair trial. The state has not even begun to meet this heavy burden. Indeed, the motion's lack of any law or legal analysis makes it seem as if the state feels no need or obligation to do so. They didn't cite any case law in their motion. They just knew it would be rubber stamped by the judge. And it was. As a justification for its request to muzzle Spencer, the state points to the, quote, media attention and coverage throughout Arkansas and the nation, as well as public discussion on social media, as though Spencer is somehow to blame for the widespread interest in this case. It should be obvious that media coverage and public attention go hand in hand and were both foreseeable consequences of the state's decision to bring M charges against a father for defending his minor daughter from a sexual predator. The state also cites statements made by defense counsel to the press, but fails to mention the prosecutor's own public comments or that the circumstances of the alleged crime were released to the public. In fact, it would be a complete abrogation of duty for defense counsel to say nothing when the prosecution implies that Spencer's actions were motivated by something other than the immediate need to protect his daughter. Furthermore, the state's desire to minimize its failure to appreciate the danger Fosler posed is precisely the kind of information that should be discussed openly and publicly. The state should not be permitted to use this theoretical possibility or inference with a fair trial to shield itself from criticism for failures and imprudent decisions. It is Spencer's right to defend himself from these allegations by asserting his innocence, and his refusal to roll over does nothing to undermine the criminal justice process. The integrity of the trial process is only strengthened by press coverage and public oversight. In fact, the state cannot even bring itself to claim a significant and imminent threat to a fair trial, as would be required to warrant the restraints being requested here. Finding no imminent threat, the state offers an imagined one, arguing in its motion that the dissemination by any means of public communication of any out-of-court statements relating to this case may interfere with the rights of the defendant and the state of Arkansas to receive a fair and impartial trial. It is of little import that public communication may reach the ears of those citizens who might eventually serve as jurors in this case. The First Amendment does not bend to mights and maybes. I like that. The First Amendment does not bend to mights and maybes. I think we need a t-shirt. Without a compelling state interest represented by a real threat to the integrity of these proceedings, the state's unconstitutional request for free speech restraints should be summarily rejected. Even if the court were to agree that possible future communications pose an imminent threat to these proceedings, the remedy requested by the state is by no means narrowly tailored to address such a concern. The proposed gag order is absurdly broad. It would prohibit public comment on anything that might be considered relevant to Spencer's defense and would shield the court and the state from the exact sort of public scrutiny a fair criminal justice system demands. By banning mention of any possible evidence that would support Spencer's actions, the proposed order effectively prohibits public criticism of the mystifying decision to release Michael Fosler back into the community with little restriction after it should have been determined that he was dangerous, or of the state's unjust decision to accuse Spencer of M. By preventing discussion of evidence tending to establish innocence, it prohibits really any comment about the case that anyone would care to hear. Worse still, for Spencer to even say the words, "I am innocent," publicly would violate the proposed order. To restrain the First Amendment rights of Spencer and numerous others to such an extreme degree before any threat to a fair trial has presented itself, and before any other protective strategy has been attempted or even considered, would be plainly unconstitutional. To even consider imposing an order that complies with the Constitution, the court must be far more precise about the risk of danger and corresponding restrictions. As written, it's impossible to know what is even covered by some of the suggested provisions. For instance, counsel do not know what information item number 8 in the state's list seeks to restrict from the public. The order should not prohibit expressions of innocence, nor should it prohibit the discussion of information bearing on the prosecution's actions that the defendant has found through his own investigation. Defense counsel would agree that documents provided in discovery would not be publicly disseminated. At this point, discovery has not even been exchanged. If at the time of trial, press coverage and public commentary surrounding this case have clearly created an atmosphere in which the neutrality of potential jurors is uncertain, voir dire would be the appropriate remedy. Thorough voir dire would be the appropriate remedy. Because the prosecution has failed to demonstrate a compelling state interest, which might justify a narrowly tailored response, and instead has opted to request the most restrictive measures possible to meet a completely imagined threat, the proposed gag order is unconstitutional and must be denied. Granting this gag order will violate Spencer's due process rights to a fair and public trial pursuant to the 6th and 14th Amendments, and his First Amendment right to speak pursuant to both the Arkansas and U.S. constitutions. The defendant requests a hearing in open court on the state's motion. That was not granted. They did not get a hearing. I know, I'm trying to get Aiden interested in this. He's on vacation right now, Flo. He's on vacation, but we did talk about it when he came on my show for his interview or conversation. We had a nice conversation. He sounded interested, so I think yes. I hope so. Wherefore, for the reasons stated above, the defendant respectfully requests that the state's motion for a gag order be denied and for all other just and proper relief to which he is entitled. XOXO, Aaron Casanelli and Michael Kaiser, Lassiter and Casanelli, attorneys for Aaron Spencer. I'm not familiar with these attorneys. Anybody who's local in Arkansas, let me know what you think about, or if you know anything about Aaron Casanelli or Michael Kaiser. And if they would like to come onto my show and talk about this case, they are welcome to. My DMs are open, as is the email. My email is in the show notes below. It says inquiries, and then it has an email right there. I would advise probably Aaron Spencer's wife not to speak on any shows, but the attorneys They are good attorneys, says Amanda Erickson. Thanks, Amanda. Take that down. Go to your questions. Before I read we got back to the judge's order, which I think we looked at one other time, but we're going to look at it again. Prayers up for New York, says going off the rails, Jen. Thanks, Jen, for being with me for 10 months. New Hampshire one says, a live day from my hubby. 20 years ago, he was wounded in Iraq. Oh, I'm so happy for you that he's been with you for 20 years. That's amazing. Prayers up, and wishing you all of the good things, New Hampshire woman. Kelly Applegate says, I'm here to do all I can to support this incredible father. Thank you again, Melanie. Thank you, Kelly. Thanks you guys for caring. I mean, look, this is a very small crowd for a live stream. It is, but there's breaking news happening in New York. And for some reason, people want to keep talking about Karen Read. There's nothing really much to talk about Karen Read today. I'll tell you what happened on Karen Read today, but I couldn't fill a whole show with it. And at the end of the stream, I'll tell you what happened on Karen Read today. But this is really important, and time is of the essence here, and we got to get the word out. You guys got to share it. You got to let people know. Thank you, Laura. Laura says, if this happened to me when I was a young girl, my dad would be in Aaron Spencer's shoes as well. Outrageous. Free Aaron Spencer. Thanks, Laura. Not that, Dina. Says, so many kids wish their dad was Aaron. That chokes me up. Thanks, Dina. Thank you for your 10. Stephanie says, survivor of severe DV with my tiniest, I'd gladly serve to protect my sweet boy. I'd gladly serve life to protect my sweet boy. Also have a JD, and all common and educational sense would go out the window. Free Aaron. I'm sorry that happened to you. And I think a lot of us have that very strong parental instinct. I have 5 kids, and I'm going to keep my thoughts to myself on that. Mary, thanks for becoming a new member. John Miller says, this is just common sense. I'm outraged. Thank you, John Miller, for being with me for 10 months. And Gigi's got the silver bracelets already. Says, he was unalive quicker and less painfully than had that been my daughter's son or granddaughter, grandson, and I found him. He has met his daddy, Diablo. Gigi. And then Gigi said again, other victims? Without a doubt. Victims testify, his past comes in. Depositions anyone? This judge is shitting a brick. Well, I don't think they do criminal depositions in Arkansas. I don't know. Not a lot of states do criminal depositions, but let him out. You are responsible for what happened. Yeah, it's a problem. It's a problem. Why do you think the judge wants to keep hold of this case? Maybe that's why. I wonder why they haven't made a motion to recuse her yet. I mean, the trial's coming up pretty soon. Mag in Florida says, dog history. The dog that alerted Aaron's that night was rescued by Aaron on a highway, then adopted. Dogs are lifesavers. Oh my God. Thank you for telling me that. Guys are going to make me choke up even more. Dark Willow says, hey, so happy to catch alive. You've been with me for 21 months. You're like an OG. We just had our 2-year anniversary, by the way. We need to, I know, have a party. Get all the peeps on here to have a party. Because it's exactly 2 years since my first live stream. And I have the silver play button plaque, the 100,000 plaque that I haven't unboxed yet. And we're at up to over 125K. I don't think anybody's out there protesting for Aaron, EBH. It's not far from the Little Rock, Arkansas, the Bill and Hillary Clinton, Arkansas airport. So it wouldn't be hard to get there. Yannetti Spaghetti's been here for 13 months. Virtual Juror says, sent image of MOFO to your email. Thank you, Virtual Juror. Let's see. This picture should be everywhere. Oh, that's right. There was a picture. Yeah. And you know what? Yeah. Okay. You guys got to see this picture. Thank you. I remember seeing this picture. And I didn't want to put it on my thumbnail because I didn't think he deserved the time of day. But now that you're mentioning it, or now that you sent it to me, I do remember seeing it. So I'll show it to you guys so you can see this POS for yourselves. I don't know how old this picture is, but 67 years old, this guy. Okay, that's Aaron Spencer on the left with the turkeys, and this is Fosler on the right. Thank you, Virtual Juror. I do remember seeing this now. Deanna, the audio bird says, if you check out the boys on the tracks doc, please definitely let us know if it fits this level of weird. I'm related to Mr. Henry from these boys, and my family has theories. Okay. All right, now you've piqued my interest on this. Boys on the tracks. Where can I find? I mean, I'll search it up and find it. Thank you, Deanna, for your 20. Sarah says, Colin Griffith can accidentally kill both his parents and get self-defense. But a father protecting his daughter needs to be imprisoned. Love you with all of my heart, Sarah and Liz. Hi, Sarah and Liz. Well, he's out on bail right now. It cost him $150,000. So he is not imprisoned right now, thank God. But yeah, exactly. It's going to be up to a jury. And he's got a good case of self-defense based on some of the details that we read in another article when he was able to get the guy out of the car and get a hold of his daughter. He reached for something. So I'm sure that probably Aaron Spencer didn't know if it was a weapon or not. And he unloaded his clip into him. And, you know, some people need killing. Sorry, but not sorry. Michelle, thanks for the 20. My dad would have done the same. My only concern would be to make sure my daughters knew what happened to them was not right. And their attacker is not breathing. Kids don't get justice in the court system. No, they don't. No, they don't. And you know how traumatic it's going to be for her to have to testify? Traumatic. Tracy is here. Everything a prosecutor says they're entitled to a fair trial. Every time a prosecution says they're entitled to a fair trial, I scream the Sixth Amendment doesn't apply to you. Me too. Doesn't apply to them. Deanne gifted 5 memberships. Thank you, DNB. Thank you. Edwina says this will come out with an acquittal for Aaron. We are with the Spencers. Thank you, Edwina. David Johnson says, reach out to Random Patriot. He has a big following in Arkansas. All right, Random Patriot. Or tell him to reach out to me. Either way, we can hopefully connect. Maybe he'll go to court. Pierre says, this case tears my heart out. Such a good dad. 20 months. Thanks, Pierre. And Gigi gifted another 5 memberships. Thank you, Gigi. Weird Debbie says, thank you so much for covering this case. I know. I wish more people were interested in hearing about it. It's okay, because we're going to share it out there. Let me show you what else I found. Well, first, let's look at the gag order that the judge issued 1 day later on December 10th. We looked at it on another stream, but since we're covering the papers, we're covering the papers, we need to, we should cover the order as well. So we have it all together in one show. Having a lot of problems today. All right. Here is the gag order. Signed, Lonoke County, Arkansas, 1st Division, December 10th, 2024. It was just lifted on, what did I say? June 20th, after going all the way to the Arkansas Supreme Court. And you know how much that probably cost? A lot. And I don't think he's got public defenders. He's a veteran. He's a combat veteran. Aaron is out on bail, yes. Here's the gag order. In view of the apparent public interest in this case and the extensive news media coverage as a result of such interest, and because it appears to the court that the dissemination by any means of public communication of any out-of-court statements relating to this case may interfere with the rights of the defendant and the state of Arkansas to receive a fair and impartial trial, and further to seek a fair balance between the constitutional guarantees of a free press, the following order is hereby entered. She didn't have the hearing that they asked for. No oral argument on this stuff. It is the order of this court that no party to this action, nor any attorney or agency connected with this case, directly or indirectly, nor any judicial employee or officer of this court, nor any public official now holding office, including but not limited to law enforcement officials, nor any agent, deputy, or employee of any such persons, nor any person subpoenaed to testify at the trial of this case. And then she handwrites in here, neither shall the defendant nor his family do any of the following. So she gagged the defendant and his family as well. It's unheard of. That's what Amanda said. Amanda says she just does whatever she wants with the swipe of a pen. Barbara Elmore does what she wants with the swipe of a pen, just like Judge Canoni. And this is what they were prohibited from doing. Release or authorize the release for public dissemination of any purported extrajudicial statement of the defendant relating to this case. Release or authorize the release of any documents or exhibits or any evidence, the admissibility of which may have to be determined by the court. Make any statement for public dissemination as to the existence or possible existence of any document, exhibit, or any other evidence. Express outside of the court an opinion or make any comment for public dissemination as to the weight, value, or effect of any evidence as tending to establish the guilt or innocence of the defendant. Make any statement outside of court for public dissemination as to the weight, value, or effect of any testimony that's been given. Wow. I mean, she really went all out here. Issue any statement for public dissemination as to the identity of any prospective witnesses or their probable testimony or the effect thereof. Make any out-of-court statement for public dissemination as to the weight, value, source, or effect of purported evidence alleged to have been accumulated as a result of the investigation of this matter. Make any statement for public dissemination as to the content, nature, substance, or effect of any testimony which may be given at any proceeding related to this matter with any attorney of record or any agent thereof. This order does not include factual statements of the defendant's name, age, residence, occupation, or family status. 2, the circumstances of the arrest, namely the time and place of arrest, the identity of the arresting and investigating officers and agencies, and length of the investigation. 3, the nature, substance, and text of the charges, including a brief description of the offenses charged. 4, quotations from or any reference without comment to public records of the court in this case, or to other public records or communications heretofore disseminated to the public. The scheduling and result of any stage of the judicial proceeding held in open court or in an open public session, except for she sealed the arraignment, was not open to the public. Any requests for assistance in obtaining evidence. Oh yeah, like if anybody out there has been a victim of Michael Fosler, please come forward. I'll make that plea. Discussion by any witness or prospective witness of any matter in connection with the case with any of the attorneys representing the defendant or the state. Oh, so she allowed any witnesses to talk to the attorneys. Well, that was nice of her. And then she handwrote in there, all parties and the defendant is under a gag order with her initials BE. Copy of this order shall be attached to any subpoena served on any witness in this matter, and the return of service of the subpoena shall include the fact of service of a copy of this order. In addition, any information violating this order shall be redacted from any paperwork related to the case that might be disseminated to the public. Then she goes one step further, a big step further. She says, this order shall be enforced until this case has been disposed of, meaning until there's a conviction or an acquittal, or until this court orders otherwise, and then handwrites in here. This order will help ensure all parties get a fair trial. Again, all parties. And then she says the entire case is now sealed. XOXO. Barbara Elmore. We need to do a deep dive into BA. Barbara Elmore. So yeah, you can talk about public filings, except I'm going to seal the whole entire case. So what had happened was defense attorneys appealed it to the Arkansas Supreme Court, and they issued a scathing reversal. Scathing. And we covered that. I think it was in the last show that we did. We covered the Supreme Court opinion. But then I was able to get my hands on the papers. And so I wanted to go over the actual papers with you. I also, so you can go back to see the Arkansas Supreme Court decision. It really spanked her. Pretty bad. Some guy with cancer says my uncle was her neighbor. The judge's neighbor? Really? And as always, I'm sorry about your cancer. I hope you're doing well. Hang on a second. Got a lot of notes and I just got to find them. Oh, please. We're going to have to get back to Kelsey Fitzsimmons, too. There hasn't been anything, I don't think, that happened on Kelsey Fitzsimmons, right? Anything new? Also, I've heard that the closing arguments are tomorrow on the James Craig case, the crazy dentist who maybe allegedly poisoned his wife case, which we covered at length, and then we're told it wasn't going to be televised or even a Zoom. And so tomorrow is closing arguments. Apparently the defense did not put on any case at all. They just rested. So the James Craig case is over except for closings tomorrow. Does anyone know if they're going to be televised? It's wild. That's in Colorado. So I don't know. No, I believe she's elected, this judge. They told me that judges are elected in Arkansas. Venus Blue says Hitler in Idaho did this. Gagging the victims is gross. Yeah, thank you, Venus Blue, Child Bunny. Thought I had the Supreme Court arguments on this. Let's see. I have to find out where I put them. Because we can look at that another day if you're interested. Unless I'm complaining with another case. Yeah, Michael Pepper, I don't know, but I can't have that P word in the chat because then we'll get stricken. But I don't know why they're roaming free. I just don't. Where they walk free, but someone has a little too much pot on them and they lock them up. Well, not in every state, Michael Pepper Tech. Not in every state. You think the closing arguments are going to be televised, Purple Draft, or they're going to have like cameras in the courtroom, but they're not going to televise them live? Like it's going to be on a delay? So I would like to watch the closings on that with you. Yeah, I thought Lawyer Lee was going to the courtroom on that. I thought she was going to the actual trial, no? She's been watching it on Zoom every day? Ham Sammy So Scandy says, clearly this guy is just a total monster. Look at him loving on some turkeys. Give me a break. No, the turkeys is the dad. The dad was holding the turkeys. The other man, that was the predator. This man is not only a hero, but a true testament to what a father should be. Agreed. Venus Blue. Oops. That is said about Hitler. And then J. Michael RN said, with all this mess going on around the country, how can we have any confidence in the legal system, the police, the court, the clerks? Is anyone trustworthy? Well, what we need to do is we need to shine a light on it, and we need everyone to know about it, and people need to start paying attention. And people need to, if you vote for judges in your state, do your due diligence. It's not going to be on television. Do your due diligence and research the judges that you're voting for. It's wild. Oh, hold please. Hold please. So the arrest affidavit has been sealed, but there was one article that I don't know how they got a copy of it because it's sealed and I can't get it. But this is from the Arkansas Times, and this is an article from June 24th. And somehow they got a hold of the arrest affidavit on this case on Aaron Spencer. And they said, after the Arkansas Supreme Court ordered the court files be made public, we now have a clearer picture of what happened the night Aaron Spencer killed Michael Fosler, a Lonoke County man who had previously been arrested and charged with S offenses against Spencer's teenage daughter. The court's records had been sealed pursuant to a broad gag order from Circuit Judge Barbara Elmore. But last month, the Arkansas Supreme Court struck down the gag order and criticized Elmore's actions. According to the records obtained by the Arkansas Times, Spencer initially called 911 just after 1 a.m. on October 8th of 2024 to report his 13-year-old daughter missing. Spencer told police he'd been awakened by his dog barking, went to his daughter's room to check on her, and saw that she was missing. He said he suspected that she was with Fosler, 67, who had been arrested in July and charged with 43 felonies, including SA of her and internet stalking of her. And also, I can tell you from what we looked at, the pandering charges, which means that he had possession of things on his phone, let's just say, like photographs and other things. The arrest affidavit for Spencer says he went to look for his daughter and Fosler after calling 911 the first time. The Lonoke County Sheriff's Office contacted Cabot Police to ask them to check a specific address. Prior to hearing back from Cabot Police, however, 911 dispatch got a second call from Spencer, who said he had located the man who kidnapped his daughter and his daughter, but that Fosler was dead on the side of the road and that he had no choice. I mean, I gotta agree with him, but let's hear more, because this is more details that we did not have before. The affidavit contains Spencer's recounting of how the deadly interaction unfolded. Spencer saw Fosler's white Ford F-150 turn onto Highway 236 East toward Fosler's home. He turned around and chased after Fosler's vehicle, flashing his lights and honking his horn to get Fosler to pull over. When the two vehicles arrived at the intersection of Highways 236 East and 13 North, Spencer rammed his truck into the rear of Fosler's, sending the F-150 into the ditch. The affidavit continues. Spencer then stated that he exited his vehicle with his firearm in hand and ordered Fosler out of his vehicle and to lay down in the ditch. Spencer stated that he observed his daughter trying to exit the passenger side of the vehicle, but it appeared that Fosler had grabbed her and stopped her from getting out. Spencer then stated that Fosler exited his vehicle and had something in his hand, but Spencer did not know what it was. Spencer stated that Fosler then lunged towards him, saying, "F you." Spencer stated that he then opened fire on Fosler, emptying his weapon before jumping on top of Fosler and pistol whipping him. Spencer then stated that he got his daughter out of the vehicle and returned to his truck, where he reloaded his weapon and called 911. According to the police report, Spencer shot Fosler in the chest, arms, and abdomen with a Glock 19 Gen 4 pistol. The report does not say how many times each body part was hit, though a standard magazine for a Glock 19 holds 15 rounds. Regarding the pistol whipping of Fosler, the report notes that there was, quote, blood on the outside of the weapon when police recovered it. Spencer bonded out of the Lonoke County Jail the following day. The case quickly drew attention both inside Arkansas and beyond. And then on November 27th, prosecutors charged Spencer with second-degree M and commission of a felony with a firearm. That same day, his attorneys issued a statement calling him a decorated war hero who protected his daughter, loving father. We read all that earlier. And then it goes on to talk about prosecutors asking the judge for the gag order the next week. The defense attorney's 19-page response. Oh, listen to this. Spencer's attorneys filed a 19-page response, which we just read, to the prosecutor's motion on December 9th. Less than 30 minutes later, Elmore granted the prosecutor's motion and entered a gag order, which we just read. Less than 30 minutes later. She also sealed the entire case file, despite neither side requesting it. Spencer appealed the order, and in March, the Arkansas Supreme Court stayed the case pending their decision. On May 29th, the High Court struck down the gag order and sent the case back to Lonoke County for further proceedings. Right, but it wasn't until June 20th that Judge Elmore unsealed the file and removed the gag order. Pretrial hearing in the case is now scheduled for August 8th. A 5-day trial is set to begin on September 22nd. So shout out to Matt Campbell for his excellent reporting, because nobody else has seen that arrest affidavit. We can't get it. It is sealed. tight. So I don't know how he got it, but that is some excellent investigative reporting, in my opinion. What say you? Back to the chat. Oh, Matt's an attorney? Oh, thank you, Amanda. I'm going to have to email him. Matt Campbell. That was a great article. Evil walks among us. Talk to your kids. Marcy Cruz says, like 100%. Talk to your kids. You have to talk to them. You have to talk to them often and early. Often and early. They have to know that they can come to you and you have to believe them. Thank you, Marcy. Ham Sammy says, just doing a sarcasm. I knew it was AS with the turkey. Oh, okay. I was like, what? They're also, yeah, so let's take a look at the obituary for his wife. Okay. Fosler's wife died June 14th of 2023. Yes, I have the court's website and I have all the documents I've been through are the ones that I could get a hold of, but that one is not one of them. But thank you so much. Arkansas is very friendly unless they just decide to seal it. What I also cannot get, and I will show you the receipts on this, is here's the court docket on Michael Fosler's case. Okay, let me share my screen with you. One sec. Here's the Michael Fosler's case file docket, and the docket entries, the criminal information sheet. That's what I want. Can't get it. You can't get a copy of it. That would have all of the information about all the charges and all the probable cause, affidavit of all this stuff sealed up tight. I can get my hands on this, order to seal the affidavit. I can get that, which says this, September 4th, 2024, by guess who? Judge Elmore. This court, having considered all the facts and law, hereby orders and adjudges that the affidavit shall be sealed due to a minor victim. Well, could have been redacted. So she sealed it on September 4th. To this day, it has not been unsealed. This is Fosler's. So he waived the arraignment and pled not guilty September 5th, 2024. You can get a hold of that. And he signed off on it. Signed it. It says here, pretrial conference, December 3rd, 2024. Jury trial, December 4th to 6th. This was his lawyer, Hubert Alexander from Jacksonville, Arkansas. That was filed on September 5th of 2024. Waiver of arraignment and plea of not guilty. And that's just a form. Doesn't say anything about like the details or the information. I have the charges that we listed them. We went through them on one of the first streams that we did on this. So we just know what the charges are, but no details about them. And then they filed this incredibly like boilerplate motion to suppress Michael George Fosler. And it's just like, oh yeah, pursuant to this, this, and this, any illegally obtained evidence, any statements made by the defendant, we want you to suppress it. He was subjected to an unlawful arrest. This is what I call scratch and sniff motion. This is like a form. There's no details in it. Everything was illegal. You did everything illegally. It was unreasonable. You didn't have probable cause. But there's no detail. This is the laziest motion I've ever seen. Laziest. The search cannot be justified. The items seized were not in plain view. There's no detail at all. Any statements given him by him were, unlawful detention and arrest, literally a scratch and sniff motion that this attorney must use in every single case. It's lazy and it's got nothing. It's got nothing. And then October 29th of 2024, after the demise of the defendant, there's a motion to seal the death certificate by the prosecutor's office. On the 29th day of October, upon request of the Lonoke County Prosecuting Attorney's Office, the state requests that the death certificate for the above-mentioned defendant be sealed due to the relatives' addresses listed on the certificate. Really? You can't redact it? Do they not understand how redaction works in Arkansas? XOXO, Chuck Graham. And then, of course, probably 10 minutes later, the judge orders it sealed. This court, having considered all the facts and law, hereby orders and adjudges that the death certificate shall be sealed. What law? There was no law in that motion. There was no law. None. I mean, if you thought Massachusetts was bad, Arkansas doesn't want you to know nothing about nothing. Boston Girl says, thanks for bringing awareness and attention about this and giving a voice and platform for those who need it. I know I have a platform. I'm going to use it. It's going to be we're going to be the new Innocence Project of YouTube. It's wild. All right. Because there's a lot of people who need to be freed, apparently. And Aaron Spencer is absolutely one of them. So in the obituary for the wife, her name is Jane Ann. Her nickname was Janie Fosler. She died June 14th, 2023. And it says, Janie Ann Jesuit Fosler walked through heaven's gates on Wednesday, June 14th, 2023, after a lengthy fight, 8 years with cancer. She was born September 17th, 1959 in Chicago, Illinois. She was a beloved sister, wife, mother, grandma, aunt, and friend. She was an active member at Our Savior Lutheran Women's Missionary League and Tuesday morning ladies Bible study. She was able to work her dream job at Arkansas Children's Hospital for 15 years. She loved God, caring for her family and grandchildren, reading James Patterson books. That's ironic, isn't it? No, Scott, the papers were sealed. I believe they're sealed. We can't get them, but that's a great idea. Watching birds, helping others, gardening and baking. Janie was preceded in death by her parents. And then I don't want to publish this because it includes like all the relatives' names and stuff. But apparently I found her funeral streaming on YouTube. You can find it if you want. And she seems to have been a very pious woman, very involved with the church. And he can be seen at the funeral work in the room. So his wife died of cancer. She had been fighting an 8-year-long battle 1 year before he started with Aaron Spencer's daughter. And it wasn't the first victim. You know that. We've been doing this a long time. This ain't our first rodeo. So there's that. I know it makes me ill too. It makes me really ill. Thank you. Thank you, Anna, for sending this to me because I was trying to find his booking photo. Like I was looking for a mugshot. I'm like, why is there no mugshot of this guy? And of course, Anna sent it to me. So hang on. I gotta thanks, Anna. You're the best. Everything's been scrubbed from the internet. I'm telling you, there's not a lot you can find about this guy. There's no mention of him being a cop. There it is. Booking date 7/11/24. But he got out, and he wasn't really indicted until September. Yes, that's what it is. His wife's obituary says They moved to Arkansas because of his military career. It does say that. I forgot that part. It says, survivors include her husband, Michael George Fosler, her sweetheart of 44 years. They relocated in 1995 from Indiana due to Mike's military career. Right? Do you believe it? And then, of course, Anna also found out where he's buried. he's in Fletcher Cemetery in Hamlet, Stark County, Indiana. Oh, they brought him back home to bury him, huh? I wonder if that's the same place his wife is buried. You're a good online sleuth, Anna. What a creep. His tombstone search shows him in a police uniform. Hang on. I didn't know there was such a thing called findagrave.com. I had no idea. Hang on. I'll have to look at it now. Now we got to look at it. Because you're teaching me things every day. You think I teach you things? You teach me more things than I teach you, probably. Here it is. Here's this findagrave.com. Who knew? Husband, father, and grandfather. And there's him in his military garb. Wow. I didn't know it was a thing. I didn't know the grave is connected to Ancestry.com. Look at Smurf Anna. Smurf Anna's got all the deets. Okay. I thought I'd seen it all, but no. I wonder if she knew what her sweetheart was doing. I don't know. I can't believe that she could be the only victim. Michelle, what exactly does case law define public dissemination as? Does it mean to intentionally share information for public consumption? Well, I'd have to look up the law in Arkansas. And so I don't know. You could probably Google it. I don't have time to get into it right now, but public dissemination, posting it on the internet, speaking to the press, saying something to someone who you know will publish it. This judge didn't really give any reasons for her rulings or giving any definition around her ruling, but the Arkansas Supreme Court had a nice fun time spanking her in a very, very long decision, which we read one night together. Venus Blue, can you tell us your real TikTok name? I tag you in true crime stuff, but I think it's your fake account. Haha, love you with all my heart. I haven't been on TikTok in a while. Hang on, because I know there's a fake account with my name on it too. So let me show it to you, because if I didn't like the thing that you tagged me in, it's just because I'm so busy that I haven't even been on TikTok. I do like it, but you know how TikTok is like a time suck, right? Hold on. Hang on. So this is the fake TikTok of me. So this is the wrong one. I can't get TikTok to even take it down. So I don't even know how to get them to take it down. This one that has all the nice graphics and everything, that's not mine. This one is not me. Mine has a different photo. So this is attorney.melanie.l is pretending to be me, has more followers than I do, but they have 12,500 followers and zero. They're not following anybody, but they have used just about every piece of content of mine to make very nice videos. In fact, I sent the person running this account a DM saying, listen, you do great work. I would actually hire you to clip content for me. You're using all my content and you're monetizing it. I've tried reporting it. They won't take it down. That's not me. If you could report it, I would love that. That'd be great. I don't know how you get verified on TikTok. I don't know how you get verified on TikTok. I don't know how you get the little thing. I don't know how you monetize on TikTok. So I have no idea. But it's not me. I don't even know how to get to my own profile on here. McCabe's or Albert's behind fake name. That's not me.
I think I've watched Kaylee's sister Olivia's impact
Wait,
statement.
stop. Here's my profile. So my profile has a black and white picture. I only have 8,800 followers, but I'm following 79 people. And mine's just attorney.melanie, I guess. I have no idea, but this is the real me on TikTok. And so if you've been I've tried reporting it. They don't care. They just don't care. How do you get verified on TikTok? So I don't know, but that's the real me on TikTok in case you care. Fake celebrity. Yeah, I know. So it's the black and white one. That's me. EBH says wives no. Wives no. I don't know, but actually, I don't know if public dissemination requires intent. And I'm thinking back on it. It depends. I can't answer that question right now. I can look it up, but I can't. You've been tagging the fake me. I wonder if you try talking to that person, if they'll talk to you. That's what I'm more fearful of, that the person is out there like DMing people, pretending to be me and engaging with people, like asking them for money or stuff. Like that's wild. All right. So here's what happened in the Karen Reed case today. She filed a motion to try and get her Lexus back and her phone. And apparently this lawyer that filed the motion is a new guy, Stephen Buzang. And apparently Lally's not responding to the request to get her car back and her phone back. So that happened. But apparently her new attorney represented one of Whitey Bulger's enemies because, you just can't make it up. I don't know why Yannetti or somebody didn't. I am not on Twitter. I do not do Twitter. Do not engage on Twitter. If you know the lore, you know the lore. So that's interesting that this new attorney, I don't know why Yannetti didn't file it for her, because they're all still her attorneys, but he represented Whitey Bulger's enemies. So that's interesting. And Ted Daniel posted about it today. So, that's really like the only thing I could think of to tell you about that happened on Karen Reed. This is something else that you want to know about. Yeah, you can report that fake TikTok if you like. That would be great. That'd be great. Let me see if we have an update on the tragic events in New York City. Oh, according to the New York Post, which is always a rush hour bloodbath is the title of their stream. Rifle-toting New York City shooter kills 5, including an NYPD officer, injures several before turning gun on himself at Blackstone NFL HQ. Oh, we looked it up before, and I said the NFL HQ is in there. And I'm going to show you a picture of him. Tell me this guy doesn't look like Jussie Smollett. Can't go anywhere anymore. I'm just going to stay home forever. Doesn't he? He's reminiscent of Jussie Smollett to me. And there's pictures of him. The devil is really working overtime. You can't. It's heartbreaking. It's heartbreaking. And you're going to say, NYPD was there in seconds, and you're going to say what is going to go down for, cross between Lenny Kravitz and Jussie Smollett. Yeah. Yeah, Green-Eyed Southern Girl. Yeah. And they ID'd him, and we talked about that earlier, but this is tragic. We're going to have to come back to this because I just can't do it right now. I just don't have the headspace for it. What do you want to talk about tomorrow, you guys? We got a show to do tomorrow. What do you want to talk about? There's that other motion that other decision that we did not talk about on Brian Walsh, the one for the search warrants of the house and the car. The decision on that, because that was like, hold on. I don't know. Peter Tragos just posted something about criminal charges against Jeffrey Knight, the operator of the vessel that struck the Clearwater ferry, resulting in the death of Jose Castro. He says this is a deeply painful time for our family. Was that person part of his family? That's just tragic. Oh no, maybe that's his client. Okay, and that's the statement from the. Okay, never mind. Okay, is there anything new on Kelsey? Nothing new yet. Oh, we could do the Walsh thing, pizza, and whether pepperoni or mushrooms are better. I like the one time, Scott, I said that because you're a Long Island guy too. A New Yorker who loves pizza, and we do not allow pizza. We do not allow pineapple and ham on pizza here. It is sacrilege. It is not a thing. We don't do that here. But I like onions, mushroom and onion on my pizza. You like both? Do you like anchovies? You like pineapple and ham on your pizza? Like mushroom and onion. Sausage and onion is good. Zozich, the meatball pie is always good. A garbage pie is always good. Garbage pie is always good. Yeah, no pineapple. Pineapple's like sacrilege. I mean, I like an anchovy, but not on my pizza. I like an anchovy on my Caesar salad, but not on my pizza. I don't know. All right, I'll think of a topic for tomorrow. I like a daytime show tomorrow, I think. But make sure you have all your notifications set. Right? And you have all your notifications set, and you have the thumbs up button already smashed, then we won't get you. Nobody will get your DNA. I promise you. Support the Spencer family if you can. I like regular. You like Sicilian or regular? I like regular because I don't like so much like of the puffy crust. But I mean, nobody makes a Sicilian pie like a New Yorker, right? Like Chicago pizza has nothing on your pizza. No offense to you guys. No. Dealer's choice. All right, we get to come talk about everything tomorrow. By the way, let's talk about things to watch on TV. The Hunting Wives. Does anybody watch that? I just finished it. I think I binged it in like 3 days or 2 days. I think it's only like 8 episodes. The Hunting Wives takes place in Texas. Anybody watch it? I liked it. Music to my soul. Are we sure that David and Bob are still her attorneys? I haven't seen them on any motions for Karen since the trial. Even the probation travel motion listed AJ and Liza as pro hoc without listing a Massachusetts attorney. Well, they have to be. They can't be filing anything in Massachusetts unless they're still at David Unity. So I have no reason to know. I have no reason to think they're not still her attorneys. But I know that Alan did say that I will always be her attorney. He did say that, right? So that's an interesting point. But they would have to be, supervised by a Massachusetts attorney in order to file that. The Hunting Wives is on Netflix. Yes, it's Malin Ackerman, who was in, Billions, right? She was the wife of, what's his name? Bobby Axelrod. And it's Brittany Snow. And then I started watching that TikTok documentary a little bit. But now I want something else. Oh, I started watching the second season of 9 Perfect Strangers, which I didn't watch yet. I watched the first one and I really liked it. So I started the second one. And so I'm into that right now. Yar, it's good. Craft. The Hunting Wives is fiction. It's about a bunch of wives in Texas and they're all into their guns and it's like a murder mystery. It's good. I liked it. There's some gratuitous sex in it, but what are you going to do? It's Netflix, right? It was like a mindless watch is what it was. Like an entertaining, like mindless watch that you can do stuff while you're watching it. Some TV shows you have to watch. If you're going to watch it, you have to watch it or you're going to miss something. Which is kind of like what 9 Perfect Strangers is kind of like. You have to kind of pay attention. Hi, Stephanie. Says, I'm a single mom of 4 16-year-old twins and a 12-year-old, all with a good dad. My tiniest is 2. Hunting Wives was awesome, but felt a bit let down by the ending. I know, it's kind of dopey, right? It's like they threw everything into that final episode. It's kind of dopey, but it was kind of just mindless, it's just if you don't take it seriously. I love The Gilded Age. I'm watching The Gilded Age. I think I have an episode to catch up on, right? Because today's Monday and there was one last night. Thank you, Stephanie. You have twins also. I have twins also. Mothers of twins are very special. Thank you very much for your time. The Gilded Age is great. Except I thought that, Gladys's wedding was a bit of a letdown. Like what? there's like no wedding. Like they say the I do's, and then all of a sudden they're on a cruise ship. Like we didn't even get to see like a big blowout wedding. So I do have an episode to catch up on. I love the costumes. It's filmed in New York. I love period pieces. And I just don't like Cynthia Nixon. I'm sorry, like at all. Like I just don't like her. I just don't like her in that role. I don't like her in. I also am watching the Sex and the City reboot. Oh, I think maybe I have some episodes to catch up on that too, because now I caught up, so they're only coming out every week. And how do you feel about that? The whatever they're calling it now, and just like that, like with Aiden and Carrie back together. I mean, I don't know. Oh, I love Landman. Love Landman. But like Aiden, I don't know that he's really right for Carrie. Like, I don't know what's going on with him. And then I don't want to spoil it for you, but what he did with, down there, and he's in Virginia and she's in New York, and she's got this townhouse now on Gramercy Park that is like amazing, gorgeous. But Cynthia Nixon just rubs me the wrong way in all the ways, like in that show and in The Gilded Age. Just weird. I can't wait for Landman season 2. That was great. Bachelor in Paradise. Oh, I haven't been watching that. Is it starting tonight? Oh, another mother of twins. Years of 31. Wait, Aiden's out. Wait, like from last night's episode that I didn't watch yet? Well, good. I hope so. I just don't think they're right. I don't think they're right together. I don't know. I mean, I think the brooding neighbor from downstairs, the writer, I don't know about him either. I think he's kind of like a freak. Seems like he could probably be like a violent, antisocial kind of man. I don't know. We should do that. We should, you know what? Auntie Deb has good taste in TV, and we watch a lot of the same shows. Maybe we should all like do a show where we like recap TV shows that we're watching, all the same things, Sam Elliott's going to be on season 2 of Landman. That's cool. That's going to be great. I also like Tulsa King. I love too. I don't think I really finished the second season though. Like the first season was so good. Cindy Ryan has fraternal twin boys who are 25. A lot of moms of twins in here. And look at Taylor Confetti Fairy is an identical twin, and your twin sister has twins. I don't know how my mom did it. It's hard. You have to have them on a really good schedule. And I would highly recommend a baby nurse for the first couple of weeks because it's hard. It's really hard. Oh, the Billy Joel documentary. I got to watch that because I love Billy Joel. He's like my favorite. Landman is a show about the oil business in Texas, and it's Billy Bob Thornton, Roller Skate 57. And I never was a fan of Billy Bob Thornton until I watched Goliath, which is to date one of my favorite TV shows of all time. If you can watch Goliath and you haven't, highly recommend. And then I got Billy Bob Thornton after that. That was a lawyer show that took place in Santa Monica. This is in Texas. He's like the guy who goes out and gets the land for these oil companies. John Hamm is in it, who I also love. It is so good. Allie Larder is in it. She plays his wife / ex-wife. Really good. Highly recommend Landman. I think it's on Paramount. Right? He's from Arkansas, Billy Bob. Remember he used to wear blood around his neck? That him and Angelina Jolie used to wear like vials of each other's blood around their neck. I just don't even. I watched Nona's and I did like it. Do not watch it if you are Sicilian. Oh, that was so funny. Yeah. You're from Sicily. You're from Sicily. Your people are trash. I forget what she said, but that was very, very funny. Very funny. All right. I don't know what I'm going to do tomorrow, but we're going to find something. Let's free Aaron Spencer. And I know Green-Eyed Southern Girl is going to be boots on the ground because she lives near the courthouse, apparently. And, if this is not going to be televised, I may need to go to Arkansas for the trial. It's only 5 days in September. If I can get away and find a flight that goes to Little Rock, it's not far from the airport. So that might be something that could be in the future because people need to be out there with signs. Like, this is absurd what is going on here. I don't like it. So leave me some comments about what you want to talk about next, what you want to start talking about, go over. All right, I'm going to go find the NYPD briefing. Thank you so very much. Love you with all my heart. I don't see someone going to die. Thanks, moderators, for keeping it classy tonight. It was a small crowd, so I think it wasn't too hard for you. Stay cool, stay kind, stay classy. Do all of the things that YouTube likes for me, please. It helps a girl out. Share the stream. Let people know about this case. More people need to know about it. All right. See you tomorrow. I just don't know the time yet. Peace, my friend.